From tax incentives to wetland regulations, 2018 was certainly a big year for ag law developments, impacting producers all across the country. Today, we focus on the top 10 trends from last year, and joining us now is Roger McEowen. He's with the Washburn University School of Law. Roger, nice to have you here in studio this week.
Good to be with you, Janet.
Thanks for joining us. Certainly, as you say, it was a big time in ag law through 2018. I'm sure 2019 is going to have its own little hid-away secrets. But taxation, of course, was a huge issue on throughout for farmers and ranchers. 10th biggest development, you talk about the case involving the hobby loss rules and also the passive loss rules.
Yeah, this is, I got this at 10 in the list because it is a big issue. Hobby loss issues are big with the IRS in terms of auditing people that have a Schedule F, but also have substantial non-farm income. And the F shows a loss. So they're showing a loss on the so-called farming activity, but then they have a whole bunch of non-farm income. So that gets the IRS attention. We had a case in 2018 where the court looked at that involving a ranching operation in southeastern Utah, or an alleged ranching operation in southeast Utah, where the taxpayers actually lived and worked out in Silicon Valley in California, but they had this ranching activity that they were getting started, putting a lot of money into it and running losses for 15 years. Now the losses were coming down, but that's what gets the IRS attention.
Right.
They think somebody's just kind of playing around, running up losses to write them off. The interesting thing about this case, however, and why it made the list is IRS said, no, you're not a hobby. So you can deduct your losses because the hobby loss rules don't apply, but we think you're passive because you hired a paid ranch manager to run the cattle operation that was grazing on the BLM land, and that's ultimately what sunk them. It's the first time I've ever seen the courts combine the hobby loss rules with the passive activity rules, and if they continue down that trend, down that road, that's a bad trend for agriculture. Very
interesting case. Now, Chlorpyrifos, number 2.
Well, I'm glad you could pronounce it because I'm terrible at trying to pronounce that one.
Practice.
That's a big issue. Most people know that as Chlorpyrifos.
Right.
But this is a chemical that's used on a lot of crops across the country. About 10% of the soybeans in the country are Chlorpyrifos is used on that, or whatever you said it was is used on that. But it's also used on various types of vegetables and certain types of fruits. So it's got wide application. We had a court very uniquely in 2018 that said, I'm going to cancel the registrations for that. We're going to pull that off the market within 60 days, in my opinion. Well, the bottom line is, as we go into 2019, I think Chlorpyrifos is still going to be able to be used because this matter is now tied up in appeals. There's an injunction on the court's order while it gets sorted out in the court system. But that was incredibly unique for a court to just unilaterally do that based upon allegations by the plaintiffs that it was harming children. And they ignored a lot of the USDA science on this to get to that result. So we'll see what happens in the appeals court and whether the Trump administration ultimately takes it to the Supreme Court.
And then number 8, of course, something we've talked about a lot, talking about navigable wetlands.
Oh boy, that's been a big issue, and we'll see. I'll give a teaser here. WOTUS is going to come up a little bit later in the discussion this morning. It's higher up in my list. But we had a case that came from the North Pole, of all places, this past year, where the court said, the U.S. Court of Appeals for the Ninth Circuit said that permafrost could be a navigable wetland. You know, soil, frozen dirt could be a navigable water of the United States, and it has to do with the manuals that the government was using, the Corps is using to define a wetland. They had a definition in '87 that was a lot more restrictive in terms of what the government had to establish. In other words, to be a wetland, it had to be wet, it had to be water. They changed the definition of that in '89, and then Congress stepped in '92 and said, Corps, you can't use your '89 manual. You've got to stick with your '87 manual. But they did so in a budget act, and what the court said, again, the Ninth Circuit said, well, that was done by Congress in a budget act, so it only applies for that 1 year. And so after that, the Corps is free to adopt their regional manuals and redefine what a wetland is in any way they want, as long as it's reasonably close to what the statute says. And that created the problem. In that case, the landowner up near the North Pole bought some land. They were expanding their business. They wanted to clear some area and gravel it so they could put their buildings on it. And lo and behold, that under the definition that the Corps was using, that permafrost was deemed to be a regulable wetland, and they couldn't develop the property.
Very interesting. Thanks for keeping up with all these cases. Now, you're going to join us again here throughout the morning. Again, Roger McEowen, he's with the Washburn University School of Law, joining us here on set. And we'll sit back down with Roger here to review the rest of the 2018 developments in our next hour and also throughout the morning on the Market Day Report.